I saw Mr. Lawrence is here. Good morning to you. And is Ms. Fleming, are you on the line, Ms. Fleming?
I am, yes.
Okay, very good. Great. Welcome. And then is Mr. Goodfellow on the line today?
Yes, I'm here.
Okay, great. All right. I saw that there was a notation or a documentation from Mr. Goodfellow related to the reunification counselor. And I think the purpose of today's hearing, and you all can inform me if it's different, is just seeking appointment or which reunification counselor to go with. Mr. Goodfellow, is that your purpose in today's hearing?
Yeah, and it sounds like we've come to an agreement on a counselor.
Okay, all right. Who's that person?
Allison Long.
Okay, and Ms. Fleming, do you feel comfortable with Ms. Long?
Yes, I spoke to her yesterday.
Okay. All right. And then if that agreement is just put on the record, are the party satisfied with that, then you all can move forward with utilizing her services for the reunification counseling?
Okay.
Your Honor, I did have a question. I do know that some require like a court ordering, like a formal document stating that they are appointed. Would we need to have one for Ms. Long?
That's a good question. Mr. Lawrence, do you have any input on that? Any insight?
I don't believe that they need a formal document, Your Honor. Just simply making contact with her and making the arrangements to get it going is sufficient.
Yeah, that's my understanding also. And I think Ms. Long, we've worked with her in the past, and I don't think she's required that. So if you both want to just let her know the court is good with her and providing those services, then that's great. If not, then you could notify the court, and the court could easily just draw up an order that would help her feel comfortable in moving forward. But I don't think we need a formal order at this point.
Okay, sounds good to me.
So, Mr. Fleming, Mr. Goodfellow or Ms. Fleming or Mr. Lawrence, do you have any additional items on today's case?
I don't.
No, I don't either.
Me either.
Okay, great. All right, so that'll conclude today's hearing. Thanks for the efforts to come to agreement on that, and good luck with that. Margraf is present,
Thank you, Your Honor.
representing Roberto Gall, and Mr. Gall is present. I see that he's here. Welcome to both of you.
Good morning.
And good morning. And Ms. Winkles, are you? It looks like you're online also, correct?
I am here, Your Honor. I am working very remotely in a different country. My internet is a lot spottier than I thought. So I'm going to keep the camera off just so that I can have the best connection, but can everybody hear me? And is it clear?
I can hear you great. Ms. Margraf, any issues?
I hear you fine, Ms. Winkles.
So
Thank
we're
you.
here for a couple of different things. So first off, that one, we can maybe just address the first. There's a motion to waive mandatory settlement conference. That's brought forward by Ms. Winkles. Ms. Winkles, do you have any comments on that?
Yes, Your Honor. We actually signed an agreed order. We got it over to the court last week. We're all in agreement that it's probably appropriate to waive that mandatory settlement conference. And Ms. Markgraf has also signed off on that.
That's correct, Your Honor.
I have that order here, so I will sign off on that. That seems appropriate.
And just so Your Honor is aware, just for the record, my client is also present in the court today.
Oh, okay. Thank you. I apologize. Ms. Gall, welcome. Sorry for that oversight. And then the next motion relates to the motion to rescind or modify the restraining order and also presentation on the restraining order. So from what I understand, there is the restraining order that was heard some time ago. Mr. Gall was not present due to one issue or another, and the court entered a restraining order, hasn't been reduced to writing. It's on today for that, and also a motion brought by Mr. Gall via Ms. Margraf to rescind or modify that. That's my understanding why we're here today. Ms. Margraf, Ms. Winkles, is that your understanding why we're here today?
That's correct, Your Honor.
Okay.
That's correct, Your Honor.
Okay. All right. So I have the proposed restraining order here. So probably would behoove us to address first the motion to modify or rescind that. If that's granted, then we can talk about the modification of it. If it's not granted, then we can talk about entering that order as presented. So Ms. Margoff, you're the moving party related to that motion. So I'd invite your comments, please.
Thank you, Your Honor. We'd like to note for the court, first off, that the allegation that there was an exhaustive investigation via CPS was actually incorrect, and that is the basis for why it is currently being appealed. And while it's pending, we really would like to note that there have been 3 investigations so far, essentially, and that 2 of them have found that Mr. Gall did not molest his daughter. We feel that, in fact, the polygraph is a fantastic example. The man who administered it has decades of experience and found conclusively that he was not lying. Mr. Gall was not lying when he said he didn't do what Ms. Gall accused him of doing. At this point, we feel that Mr. Gall has fulfilled every single thing asked of him by the court, by Ms. Winkles, and by Ms. Gall. And at this point, anything else is simply overreach. And we're asking that the restraining order be rescinded. He needs to move forward with working with his children to repair their relationship. And this has been interfering without question in that progress. We've submitted reports from Elizabeth Rosen, who was manning the effort to reunify the children. Some of the records actually submitted by Ms. Gall herself indicated otherwise in terms of how awful the experiences have been. There was one note in particular where Caleb noted that his father had become irritated because some papers had been damaged, and then told the counselor at Columbia Wellness that, in fact, in the olden days, it would have been a huge explosion, and he had made significant progress in the way he addressed it. We'd like to ask the court to rescind the restraining order and permit Mr. Gall to progress with his work with his children.
Ms. Margoff, thank you. Could I ask a question? It seems like part of the motion is related to notice. As far as that hearing that Mr. Gall, it seems to be the position is that there is either improper notice or an insufficient notice for the hearing in which the order was entered. Is that part of your motion also?
That is part of the motion. The notice he received had something crossed out with an incorrect docket on it. And we actually, Mr. Gall, before I represented him, submitted materials showing that he had waited on the wrong docket for the entirety of that hearing.
All right. Thank you. Yeah, I've looked at the case pretty closely. I looked at the notice issues fairly closely and dived deeply into the other issues that you've addressed. So I appreciate your input. Thank you.
Thank you, Anna.
Ms. Winkles?
Yes, sure. In a sense, so I'm hoping everybody can hear me. During all the restraining order first, it was an interesting case in that the majority of the visitation was handled on the domestic violence protection order docket. And that was decided by the court. That wasn't Mr. Gall's former counsel or myself. That was just happened to be what the court decided. Actually, we attempted to set it on that docket. The court said that they would prefer it to be back over to this docket now. So we did set that. Everything on that docket minus one place that was crossed out said that the correct docket was the docket we were serving. The docket that we were actually on. Order the docket notice that we presented to him. We obviously had met and sent that to him. So I'm not sure why, when 9 things said the correct docket and 1 thing was crossed out and said the incorrect docket, why Mr. Gall would choose the 1 out of 9. And I've given Your Honor a significant exhibit showing that. But in any event, just arguing the case again, this is a very delicate case in which I think the guardian ad litem here is probably the most useful person. My client is purely trying to protect the children from harm that she has been put on notice. And just to go back, these parties were married in 2012. They have 2 children. One is a little girl that's 10 years old. The other is a little boy. There has been extensive counseling in this, in which my client is not present for that counseling. During that counseling, and you'll see from the medical records, the children have disclosed a series of essentially horrific violence that they have and or endured during their childhood, causing the children to actually have diagnosis of post-traumatic stress disorder, both of them. One of them self-harms, that would be the little boy. We then have children disclosing that they're afraid to see their father. They're afraid to have contact with their father. They disclose in one of the counseling records that they're willing to do it because dad just got a new dog. They're afraid for that little puppy's life. They're willing to essentially put themselves at risk because dad promises not to hurt the dog. That in and of itself is traumatic for a third party to hear. It can only be described as horrific for a child to have to make a choice over their own feeling of safety or the safety of an animal. There has been extensive counseling done with these children. Mom wasn't present. Guardian ad litem did have some involvement in that and has spoken with the counselors. The thing is that when CPS delivers a founded result for sexual assault, that has to be taken seriously. Now, whether there's an appeal in place or not, at this point, we have a child that disclosed it. We have a CPS finding of it. And we have essentially a 10-year-old little girl that we don't know. Frankly, mom doesn't know if it happened or not. And we are appreciative of dad getting these sexual history polygraph. Absolutely. As the court is, this is a case where we have two children disclosing quite a lot to counselors where mother isn't present. The guardian ad litem here has had interactions with those counselors. The problem here is not that mom is trying to withhold, that mom is trying to keep dad away. The problem here is that we have a little 10-year-old that disclosed abuse. We did have a CASA investigation where a 10-year-old essentially said nothing, neither negative nor positive, essentially not stating anything about it, whether that was trauma for her at the time or not, and she just didn't want to talk about it either way. We don't know, but we do have a CPS finding of sexual assault. And while we are very thankful that dad took a sexual history polygraph, we have to be cognizant of the reason why they're not normally admissible in court. They're definitely a tool used by the guardian ad litem, but they're not admissible because they're not accurate. And by that, I mean, there are many times that comes up false positives, many times that come up false negatives, which is why we can't use them in criminal. We can't use them in family, really, because of the fact that they can be so faulty. And what we have here, dad may be appealing CPS, but what we have here is a CPS finding sexual assault. We have a DVPO that was granted after a full hearing with witnesses, with live testimony, with everything that was granted that said dad did, dad did abuse mother and children, and that is significant. We then have a father that comes on, and while he's walking the walk and doing the counseling, comes on to the majority of hearings and states that it is mom that is the abuser and dad that is the victim, and then uses, the rest of the time to talk about how the judges and the lawyers are out to get him. This is concerning. And right now, the only thing that needs to be done is to protect the children pending either the appeal of CPS or pending a full hearing or pending a trial. While dad's relationship and his bond may be decreased in that time slightly, the fact is the overall necessity to protect a child from A, direct contact leading to more sexual assault, or B, indirect contact via the telephone leading to trauma is far more significant, and the benefit of that protection far outweighs the need for dad to have contact in the interim. My client is just doing her darndest to protect these children. She's already known that the DV happened. She's concerned that if CPS made a finding that we have a problem. What we would ask for today is to have the guardian ad litem talk. That is the greater issue here, is to allow these children somewhat of a voice, and the GAL is their voice in this hearing, in this trial. So really, to protect these children, we need to know where they are mentally, and if speaking to dad, because right now he really just had the reunification and he just had the telephone contact. If that is true traumatic for these children at this time, what can we do to protect them? So I'd ask Your Honor, rather than talking to my client or having me continue to talk and argue, because really the GAL is the best person suited here to state what's happening and to state where these children are and what's needed to protect them.
Thank you, Ms. Winkles. We'll turn the time to Ms. Corey, and then we can hear from both Ms. Margraf and Ms. Winkles again after hearing from Ms. Corey.
Good morning.
Good morning.
I have been slightly removed from this case for some time since I concluded my investigation, but I have kind of kept my finger in, I suppose, and followed it. I'm fearful of the CPS findings in that if these children, and both of them, were to resume their visitation with Mr. Gall, that would be considered a failure to protect by CPS. And without that appeal to that finding, I just can't imagine re-victimizing these children in that way. I believe that further input is needed from Mr. Gall's counseling, from the children's counselors, and from CPS. But as you know, it's difficult sometimes to get information from CPS when it is a currently open investigation. That it's, and my report actually did not reflect that final finding because of that. It only reflected what was found previously. I did not have the opportunity to consider that finding in my final recommendations. As to the older son knows about these allegations toward his sister. His sister disclosed to him at some point many months ago. Not sure about the time frame exactly. He said while they were living with the grandmother. And it is as likely disturbing to him as it is to the younger child. Again, the most concerning thing to me really is the aspect of it being failure to protect if this is allowed.
Thank you, Ms. Corey. Ms. Markgraf?
Thank you, Your Honor. First, I'd like to note again that all of the more disturbing allegations earlier in the counseling, they all occurred before reunification. And since then, again, there has been outstanding progress. We'd also like to note that this entire issue revolves around a single allegation about a single incident. And there's also a medical history of this child having hygiene issues. And at one point, Mr. Gall had to apply a medication. We believe that in the stress and chaos of leaving the family home, that's how this allegation bubbled up. And I would also note, Ms. Winkles is the person who requested this polygraph and then turned around and then also requested a forensic interview. We noted at least 2 have already occurred. Neither one was especially dispositive. We don't think a third would be helpful. Again, we are only asking that Mr. Gall have supervised contact with his children because he hasn't spoken to them for months. The situation is unquestionably difficult. This was an extremely unhealthy marriage, and I think everybody has come out of here with some damage, but Mr. Gall has the right to move forward with trying to heal that. I'd also like to note that CPS, again, did not follow their own protocol when investigating this. I think Mr. Gall has shown himself to be a person who can be around children at this point. We don't have any kind of solid substantive issue that shows that Mr. Gall did this. We do believe that Ms. Gall is interfering with him seeing his children. We're asking again that he be permitted to have contact with them again.
Ms. Markgraf, were there two CJAC interviews or just one?
There was a forensic interview with the Kelso Police Department, and I believe an interview with CJAC.
Okay. Okay. All right. And then, so your request is that the reunification efforts continue and be guided by the reunification counselor?
Yes, Your Honor, that's correct.
Okay. And then Ms. Corey, do you have any input related to that specific request? And then we'll hear from Ms. Winkles.
Related to the request to begin reunification counseling again?
Right.
I think that maybe should be up to Ms. The counselor.
Ms. Rosen?
Ms. Rosen?
Yes, thank you. Sorry. I think that should be up to Ms. Rosen.
Of whether or not she feels that it's appropriate to continue to do so. Is that your position?
Yes,
Okay. Do you know what her position is on that?
I do not.
Okay. Ms. Margraf, your client, Mr. Gall's raising his hand. Any concerns if you were to share some thoughts?
I think we ought to wait, or can we go into a breakout room?
Yeah,
Is that possible, Your Honor?
yeah, it is. It is. I can place you and Mr. Gall into a breakout room and we can come back and,
Your
Thank
Honor,
you,
it
Your Honor.
it was just to answer your question, that's all.
oh, Ms. Margraf, do you feel comfortable with him answering that question?
Ms. Rosen?
Yeah, that's correct.
Okay.
So Your Honor, Ms. Rosen has been in touch with me every other week and just waiting to get updates about this core matter that keeps getting delayed. And she's looking forward to restarting reunification counseling and is keeping her schedule open.
Okay. All right. Thank you.
And-
Ms. Winkles?
Yes, Your Honor. My issue with having it be with Miss Rosen is twofold. Number one, part of our request was to request a reunification counselor closer to mom. The reason for this is that essentially mom lives obviously in a different area that's several hours away. Mom has to put both kids in the car and drive for, well over 2 hours to get to Miss Rosen's office. Mom makes essentially just a little bit more than minimum wage. Mom receives, very, very little funds in order to support the children or the family. And in fact, mom's attorney fee judgment still hasn't been paid. Mom is essentially put tasked to not only provide financially to get down here, but also just the time involved and the expense, and it conflicts with mom's work schedule. And so we have this issue. And so what we were requesting was if there was reunification counseling, that it take place close to mom. The reason for that is the party that is essentially caused the need for reunification is that there's a DVPO against dad. And that is the reason. So if the court is entertaining reunification counseling, we would ask that although it be slightly a little bit more difficult, maybe cost another, session that wouldn't normally occur, that it be with someone closer to mom. That way the children are not in the car for 4 hours out of the day after they're having something that may very well be a traumatic incident and then being essentially schlepped back and forth. Additionally, Miss Rosen didn't have any information about the CPS finding, and that needs to be taken seriously. CPS obviously found something, whether or not their investigation was valid, that comes out after a separate hearing, a separate administrative hearing where they make that determination. To just state that it was wrong without having that finding of that they did it incorrectly when we don't have any of their notes, we don't have any of their investigation reports, we have nothing like that, I think is very premature. There has been there has been deep findings of physical violence, but while dad is in counseling and reunification, the children during that time to the counselor, their private counselor, has stated that they are fearful of that and they come away from that still being afraid. That in and of itself is a problem. And the fact that the reunification counseling records don't note that. So, but she only sees who she sees when they're with dad, which may very well be separate from their actual responses to that. So my concern is that we're really kind of doing these children a disservice without allowing their voices to be heard through their counseling notes. And that's why we submitted them to the court. So my client would ask that we await the appeal from CPS. That way we know that child's protected. If your honor is inclined to do telephone visitation, that maybe it occurs while the children are actually with their counselor and not with mom, because that's a whole other issue. And if we're going to do reunification at all, that it be near mom, and that it be an agreed reunification counselor that's somewhere by mom. I'm sure we can find somebody. Lacey is up there. It's quite a large area. I'm sure that there are people available that we can get in to see very, very soon. But my client is very concerned, and CPS, their reaction is concerning. So we'd ask Your Honor to allow the restraining order to stay in place as it is. And if Your Honor is going to change it, that you change it to make it so that it protects the children in the utmost way possible. Thank you.
Thank you. Yeah, one question I wanted to ask either counsel or Ms. Corey can answer. How many sessions of reunification counseling have occurred? Not necessarily together or just individually, with Mr. Gall or with the children. What's the approximate number we're looking at as far as that have happened?
I think my client could answer that.
Mr. Gall?
Yes, Your Honor, we've had between 10 and 13 sessions to date so far. And the reunification counselor's note the last time was that the sessions would be a lot less than she anticipated because of the amount of progress that had already been taking place. One more
And I'm going to object to that last statement, Your Honor, because it's hearsay and we have nothing in the record that supports that.
Happy to provide my reunification.
So the objection is noted, and it's
Your Honor, one more thing. With regards to Ms. Winkle's last statement, I do want to update my attorney with a response to that, as she is newer to the case. So maybe a breakout room might be merited, or if I can just make a statement.
Pop on, hoping to have their case called next. I'm supposing.
We're not
Yes,
trying to do anything, Judge, but it should be quick.
we agree. So I'd ask the court to call the Gavino and Cook matter. We received the guardian ad litem's interim report on, I believe, Friday. Mr. Zandy's client submitted a declaration also on Friday. Our request is that we set this over 2 weeks. My client essentially just got the opportunity to look at that report, and we'd like to additionally be able to provide a response to that, as well as to the declaration submitted by Mr. Zandy's client. We're still in a 50-50 plan. There's no imminent danger reported, at least as to the guardian ad litem. So I think that's a reasonable request to set over 2 weeks.
Great, thank you. Mr. Zandy?
And just briefly, we did have a quick communication before court today. Certainly understand and appreciate the timing element of everything. We did get the report. I thought it was pretty thorough. I thought it was exactly what everybody anticipated from Ms. Turnbull as it relates to that. The court recalls at the last hearing, I believe it was 3 weeks ago, we kind of anticipated these quick turnaround times then. Which is why we kind of hurried to get a declaration out as quick as we could, kind of in response to that for today's matter. I'll leave it to the court's discretion. I'm not opposed either way. I certainly appreciate counsel's position. Certainly appreciate the position of the GAL and getting these interim reports turned around. So basically, I'll leave it to your discretion, Your Honor.
Okay. Yeah, I did. I read Ms. Turnbull's report, and I appreciate her efforts to get that submitted to everybody. I think it was submitted on the 24th or thereabouts. And then Ms. Cook submitted her declaration, I believe, on that same date or shortly thereafter. And so I've heard from 2 of the 3 participants. It would be good to hear what the third party has to say related to that. So and I don't think there's any great danger of continuing, because the motion right now, it's a 50-50 plan, and the motion is to change that fairly dramatically. So I'm fine with the 2 week set over. That would put us to I think the 11th of April.
Yes.
It's a Tuesday morning at 9. So if everybody's available, then we'll move it to that date, and we'll hear it then.
And I would just ask, Judge, that if there is any information that my client would like to just offer a quick rebuttal, that we reserve the right to do that. That's kind of the hard part in kicking out a quick response to things, and just so everybody's on the same page with that.
Yeah, I think that's proper, and proper to anticipate have an opportunity to respond to any reply.
Okay, thank you.
Okay, Ms. Turnbull, any questions or issues at this point?
No, thank you.
All right, thank you both for turning on your cameras. We'll set that over to the 11th. Margraf and Mr. Gall back, and Ms. Winkles, are you still with us, Ms. Winkles?
I am, Your Honor. And I also, just because Mr. Gall did have the chance to speak, I did speak to my client as well briefly. And so I'd like to add a little bit to this concerning Ms. Rosen as well.
Okay, if you want to lead out, then I could hear from you just briefly on your client's input related to that.
Okay, yes, Your Honor. After speaking to my client, she has a few concerns about Miss Rosen as well. In the original order, the reunification was supposed to be child-led versus counselor-led. And the reason for that was because of the trauma and the abuse that was disclosed by the children. Miss Corey had an active role in that as well. It appears that that was not what happened, and that the children themselves were actually informed by the reunification counselor that they would be seeing dad no matter what, and that it wasn't their choice. My client has a significant issue with that because, again, we're dealing with trauma here, and we're dealing with children essentially taking their agency and power back and feeling safe. My client stresses again the need for a different reunification counselor that will actually apply what that court order says, that is child-led reunification counseling based on when the children feel safe, not when the counselor deems them to have actually been prepared. We'd also ask that Ms. Corey, should she need additional funds, and I'm guessing that she will, considering how much work she's put into this, that Ms. Corey be actively involved in that reunification counseling. My client is willing to find a way to come up with any funds, her proportional share of that. Like I did say, she does make very, very little, but she's willing to do anything to protect these children. She would ask that if any reunification counselor, that Ms. Corey have an active role in that. And again, that maybe Ms. Corey be reappointed with or be given additional funds for that work. And that's where she's at on the reunification counseling.
Your Honor.
Thank you. Ms. Margraf?
If I could directly address that, so you're saying basically that Ms. Gall said that her children said these things about Ms. Rosen, wouldn't that qualify as hearsay? And shouldn't be considered? Basically, but to circle back, basically, one of the conditions of relocation was that the reunification counseling would be continuing in the Kelso Longview area. And beyond that, we do have a lot of concerns about the idea of ending reunification with Ms. Rosen. There's concerns regarding the just one session costs. I don't think that's true. I think there's going to be a request for a significant kind of advanced fee deposit, and Mr. Gall cannot afford that. Setting back to square one after months of successful progress with a brand new person. And finally, I'd like to note, Ms. Rosen does know about the findings of CPS. I informed her of that in February. She is aware of what's been going on with CPS. So we are asking the court not to consider the option of moving reunification counseling closer. And further, I'd also note that there is a schedule where 1 week is a session via Zoom and 1 week is a session in person. This is not 4 times a month coming up and down the corridor, which we agree would be a lot. So we are asking the court to permit Ms. Rosen to continue in that role.
Okay, all right, thank you. All right, so the issues presented here are exceptionally sensitive and important to all the parties, and especially to the children. So I want to just first address the notice issue related to the initial hearing, which was had where the order was entered. So I'll just tell you my takeaway from digging into that. I think that the clerk's papers 104, which is the notice of the hearing, it could cause a reasonable person to be confused. I think there was the indication that it was going to be on a single document. It indicated that it would be on the protection order docket, and then the other page said it'd be on the family law docket. So on those 2 dates, there on the one date, there were both dockets were happening. So I think a reasonable person could easily be confused by that. And it looks like Mr. Gall had made attempts and was making efforts to be present on that day. It's not like he blew it off or anything, that he did make efforts to be there. So I'll find that the notice was insufficient. So then we move to the next issue, which is a motion to modify or rescind. At this point, the domestic violence protection order is set aside in that there wasn't proper notice given to Mr. Gall. So what we know at this point is that there's been law enforcement involvement. They've opted at this point not to bring any charges. There's been a CPS investigation with a founded finding that's being appealed, and that there's been polygraph. Polygraph is a polygraph, so we'll give it the weight that it's due. It's a piece to consider. So with that, with those findings, at least from CPS, I guess there's a call or a request to give deference to a CPS finding. I guess that there's maybe some rationale for that, and yet I think I would abdicate the responsibility given to me to make a decision if I would just say, okay, whatever they say goes. Certainly they're trained professionals. Certainly they have training and experience in making those types of findings. And I guess the court has some similar, if not different, experience in making findings. So the concern is the re-victimization of children, as kind of enunciated by Ms. Corey. And we know that Ms. Rosen has been the reunification counselor for a dozen or so counseling sessions. So what we know, there's concern also raised by Ms. Gall that Ms. Rosen is not, is forcing her will, basically, and it's saying it's not a child-led reunification process. That would come to me as a huge surprise, having worked with Ms. Rosen for a number of years. I would be exceptionally taken back if that was the case. My experience with her, and this may be different, she may have changed, I don't know. My experience with her is that she's not going to do anything that's contrary to the child's best interest. If reunification can occur and the child will be well and safe and protected, she'll move forward. If the child will not be well, safe, and protected, she's not going to move forward. She's not going to do that prematurely. That's been my experience. And I could be off on that. Things may have changed. She may have altered the way she does things. But history tends to be a good predictor of current and future behavior. So the Ms. Gall raises issues that the drive from the Tumwater, Lacey, Olympia area to Longview is long, takes a lot of time. She has to take work off, and that it's expensive. Gas doesn't come cheap. So at this point, the reunification counseling can continue under the supervision and guiding eye of Ms. Rosen to help offset some of the costs involved there. I will order Mr. Gall to pay for the gas money at the federal mileage rate to and from the reunification counseling to mother 24 hours in advance. If that payment is not received 24 hours in advance, then the counseling session will not occur. If it is, then it will occur. And at this point, the DV protection order is rescinded because there was improper notice. If there is a desire from Ms. Gall to have a hearing on that with full input from all the parties, that could certainly be noted up, and that can be heard and addressed, and have all parties have voice. So that's the court's ruling at this time.
And Your Honor, when we're talking about the DV hearing, we're talking about the restraining order in this case, not the domestic violence protection order that was entered a year ago. Is that correct?
Yes, I'm referring to the restraining order hearing that was set for the 24th of January of this year.
Okay, thank you, Your Honor.
That's the one that I'm saying there wasn't proper notice and should be rescinded, set aside.
Okay, thank you, Your Honor.
Okay.
Thank you, Your Honor.
Ms. Margraf, do you have any questions?
No, thank you, Your Honor. I appreciate your help today.
As far as a order related to the rescission or setting aside of that, Ms. Margraf, is that something that you could draft and forward to Ms. Winkles for her review and then forward it on to the court?
Yes, Your Honor.
Okay. I'll look forward to receiving that. And at this point, we'll be notified if there's other hearings related to the restraining order.
Will Your Honor weigh in on the Zoom calls and the supervised visitations as well?
I'm not sure what you mean.
And
Ms.
I
Margaret?
would request that we have some discussion about Zoom calls and supervised visitation.
I'll defer to the reunification council at this point.
Thank you, Your Honor.
Okay, so that'll conclude things for today. Thank you.
Thank you.
And any preliminary motions from either party before I hear argument from the moving party? Okay, let me just get my notes here. This looks like this is Ms. Lauterbach's motion or related to financial relief. So, Mr. Zandy?
It is, and thank you, Your Honors. The court's aware I do represent the petitioner and moving party to the motion before the court this morning, namely Mercedes Lauterbach. I think the original motion that was filed back in the fall, as well as the supplemental declaration that was filed last week, is pretty succinct and clear on kind of what we're asking for. And that relates to some desperate need of my client for some financial relief. This is a 15-year marriage in which Mr. Lauterbach, to his credit, was the breadwinner of the family, provided financially for my client, as well as children that were in the house at the time. And my client was largely, and it's undisputed, a homemaker and mother to the kids. So that's kind of the stepping off point. Parties separate about a year and a half ago. Mr. Lauterbach pursues a business entity he's a 100% sole owner of, which is gutters and the like, and roofing. Moves to a different part of the state and essentially, kind of leaves my client high and dry on the finances. Piecing this together, since we've filed late last spring, has been somewhat problematic. Initially, Mr. Lauterbach had retained an attorney who informs that he'll provide the discovery that we had requested, and that he anticipated the case would be short-lived and a resolution would be forthcoming. That rolled into weeks, rolled into months, rolled into the fall. Thankfully, Mr. Foley gets involved. We have discussions about the same types of issues, discussed some kind of resolution on a temporary and final basis. Thought we had made some progress on that. Motions filed, that it gets set over, and unfortunately here we are now spinning our wheels to a large degree, and my client's credit card debt, personal loans, and the like that she details for you has continued to increase. So we're here asking for some much needed financial relief, and we're asking for spousal maintenance, also asking for attorney's fees and costs, and also that Mr. Lauterbach be responsible for the mortgage on the family home. I'll get to that momentarily. I think if you look through the information that was provided by Mr. Lauterbach, coupled with my client's initial motion and declaration, which support her request, you'll see that he's largely provided very well for the family. In review of his financials, the tax returns, as well as the bank statements, for the company, which is Glacier Roofing and Gutter LLC. You'll see that there's significant assets that are there. You'll see that in the information that he provided for you, there was a gross total income reported of $249,152, which gross receipts that were reflected in the profit and loss schedule in excess of $400,000. And again, based traditionally, my client details for you that there's always been more than enough. That he's always provided based on this, and we would certainly submit that the $249,000 that's reflected in his total gross total income for last year, again, is indicative of what he traditionally makes. This is a business where my client details for you, and there's very little comment from Mr. Lauterbach that he's done cash only jobs, under the table jobs. We provided you with a copy of a check in excess of $33,000 last fall, and it was part of our original motion that was filed under sealed. There's very little comment on related to these cash only jobs, but my client details that was pretty consistent throughout the course of this business. Now, certainly it's logical to assume that continues to be a source of income for Mr. Lauterbach. And we're asking the court to give some kind of deference to that, based on the history and the nature of the being your own contractor, running your own business, such as Mr. Lauterbach. I think if we look at imputing income to him. It's always interesting to see somebody who owns their own business in this capacity, kind of what they're going to assume as their income. Mr. Lauterbach is asking the court to basically adopt his proposed figures of $61,507 per year. I would submit that if he didn't own his own business, he was working through some kind of a union or alternatively some roofing company, he would be making more than that just based on regular wages. So again, we look at that kind of with the raised eyebrow a little bit as and skeptical. We think that the information that he does provide in his profit loss schedule is indicative of his actual earnings, if not understates those to a large degree. Based on those figures, we believe our request of $3,000 per month in spousal support is appropriate. Also ask for a contribution towards attorney's fees and costs, again, and another $3,000. And finally, ask that the home on Freddie Lane, the mortgage paid on that is done so by Mr. Lauterbach, again, giving the very significant difference in incomes. Now, Mr. Lauterbach indicates that my client was spending a significant period of time in Mexico. That is true. That was due to the death of a close relative of her trying to settle that estate. She is now back. She is finding it very difficult to find work, although she continues to try to do that. She was terminated from her last job, again, based on there being not enough work to go around. They just essentially let her go. Given the fact that she spent 15 years of this relationship working inside the home, has very little education or work history, so to speak of, again, kind of warrants the fact that it's going to take her time to find something to be self-sufficient because she spent a significant period of her life with Mr. Lauterbach, again, tending to the home. And unfortunately, now she has assumed significant debt. Now, we've given you information related to that, which shows that her credit cards are now maxed out, and those are modest to begin with. Now, one is maxed out over $4,000. She's overdrawn on her fiber account. She's taken out personal loans now exceeding $5,000, and we still have these questions as to kind of what's happened with the house. There's been some stuff that my client was unaware of related to the mortgage being paid and modified during COVID and post-COVID. That thankfully the offices are starting to kind of vent out a little bit as to what's going on with that. But again, the mortgage needs to be paid. As far as the assets, you have the business and you have the real property in Longview. Mr. Lauterbach has the advantage of living in a home in Trout Lakes, again, which is inherited by him. Now, we think has very little, if any, debt associated with that outside of the taxes and insurance, again, to his benefit. While my client is trying to maintain a home in Longview on extremely limited resources that is now infested with rats, to the point where she details for you in her declaration, she can't turn on the furnace or the heating system because she literally smells decaying rat carcasses. She's now putting a space heater up to heat the home. The siding is an issue. The front deck is rotten and needs replaced. And ironically, the roof needs patched and fixed as well, if not replaced, which the equipment is there. It was just never put on by Mr. Lauterbach. So my client is struggling, to say the least. She very desperately needs some financial assistance. And again, given the information provided by Mr. Lauterbach and his taxes, as well as the bank statements from the business, he certainly has an ability to pay. We recognize that the 17-year-old child is living with Mr. Lauterbach. That child seems to be doing relatively well there. Again, we can offset some kind of support from maintenance obligation. I'm confident Mr. Foley and I can work through that. But purposes of today, my client desperately needs some financial assistance. We're here as a last resort, and we're asking the court to grant the relief we've requested in our original motion.
Thank you. Mr. Zandy, just a brief question. It looks like the mortgage, principal, interest, and escrow is $1,164. Then there's homeowners insurance of $225, property tax about just under $300. So total mortgage payment or obligation each month is just below about $1,680.
That sounds about right. I think I had it just below 1,600, but I think that's pretty close. Yeah.
Okay. All right. Thank you. All right, Mr. Foley.
Good morning, Your Honor. Thank you. I guess a couple of quick comments. Mr. Zandy made a number of statements about mother working inside the home. She has, in fact, worked outside the home and worked in the childcare industry. As a matter of fact, that the last job that she had was down in Klamath Falls. She moved down there to be closer to family and took a job in a childcare facility, but left that job because they wouldn't give her time off to attend her son's wedding. Now, I'm not going to argue whether that was appropriate or not, but the fact of the matter is she has worked outside the home. My client has made the mortgage payment, Your Honor. He is current on the mortgage payment, current on the property taxes, current on the insurance. In addition, I included with our sealed source financials receipts showing transfers into mother's or wife's account, just as a sampling. Back in November of 22, he sent 1,100 in addition to the mortgage. December 6th of 22, he sent 995. January 4th of 23, there was 800. February 9th of 23, 995. And then just last week or the week before, on the 17th, sent another $995. So when you take those amounts and you combine those with what he's been paying on the mortgage, you have a very substantial sum of money going mother's way. Number two, Mr. was designated as the primary custodial parent of the 16-year-old daughter, the only child of the marriage. And that was done back in February of 2022. The child had actually started residing with father beginning in August of 2021. Since that time, my client has not asked for any financial assistance from Ms. Lauterbeck for the care of the child. And just as an example of some of the expenses, we listed roughly a $3,600 dental bill that he paid for recently. He also covers her health insurance, and that's listed on his financial declaration. He also covers her $550 for driver's ed, not to mention all of the sports that she is involved in. So if you were to take the amount that mother, even at a reduced income, an imputed income for that matter, should be paying, I mean, you know, that puts you pretty darn close to the $3,000 that Mr. Zandy is requesting. And to address the issues of the money that my client's making, if you look at the 2020 and the 2021 returns, you'll see that this family has not made, you know, tremendous amounts of money. Yeah, maybe Mr. Lauterbeck could go to work for the union, go to work for another roofer, and possibly make more money. But the fact of the matter is, he is now the custodial and has been the custodial parent since August of 2021. Having his own business allows him to be there for the child, which unfortunately, that's not something mother can say. She's demonstrated a complete lack of interest in the child, and we touched briefly on that in our materials. So on the one hand, yes, he probably could make a little more, but I think being the independent contractor gives him the flexibility to do what needs to be done for the child, to get her to her activities, and help her with the schooling and all of those things. So this payment arrangement has been going on for quite some time now. My client is actually requesting that, you know, unless wife can somehow find employment and afford the house should be sold and the proceeds divided, or at least the proceeds held pending written agreement of the parties or further order of the court. But I think contrary to what is being argued, this is not a cash cow, and there's, as far as I can tell, no reason why mother should not be out looking for work. I mean, she has no child to care for. And okay, she had some family issues in Mexico, but she was down there for months and months and didn't seem to have a problem going back and forth. So our request, and I would point out that my client did make a payment. There was an order from, I believe it was a December temporary order, where my client agreed to pay $3,500 to mother. He paid the mortgage payment. He sent her I believe it was $995, and then we forwarded on a balance owing a check to Mr. Zandy's office for attorney's fees. That I will admit was not timely because that was our error. We thought when it came into our trust account that was to be applied to his bill. We realized late last week that was not the case. And so once we realized that, we did forward the balance of roughly $1,300 to Mr. Zandy. So I only bring that up just for purposes of telling the court that there have been contribution to mother's or wife's fees with Mr. Zandy. So we'd ask that the court deny the request for $3,000. My client is still willing and prepared to continue making the mortgage payment, the taxes, and the insurance. And then, of course, he'll do what he can as far as extra money, just like he's been doing monthly. But at some point, this has to stop. And it doesn't look like mother is going to be able to afford the house, and therefore the house should be sold. Lastly, I would just ask the court to at least take into consideration the fact that my client has held off filing a motion for child support. And I think that should be given consideration when you combine these running totals. And you'll see that the break that mother is getting certainly brings us up to the $3,000 that Mr. Zandy is requesting. Thank you.
Thank you, Mr. Foley. Mr. Zandy, any brief rebuttal?
Yeah, and again, it's the $3,000 per month to help pay the groceries, pay for the gas, those types of things, in addition to paying the mortgage, which is preserving the community interest and the community asset therewith. My client is quite admittedly somewhat frustrated by this allegation that there's a lack of interest in the 17-year-old child. I think from her perspective, this is a case where she can't even afford the gas to drive to Trout Lakes to see the child. She can't even afford the basics to provide for this child, and she readily acknowledges that, and that's been part of the frustration since the onset of this case. Though Mr. Lauterbach now comes forward and says, well, I've given her some money as I can here and there. Again, that has been extremely sporadic. That has been in amounts that have not been consistent. And again, by the very information that we filed back in the fall related to the home mortgage, where my client is getting notices from the bank saying, pay or we're going to foreclose. Again, that shows that he has not been consistent in that, thus the basis for this motion. We'll just urge the court to look again at that 2021 tax return. You'll see that in part one, I think it's pretty clear. There's total gross receipts of $401,506. You take from that the cost of goods sold, which was another $152,000, which leaves you with the gross profit for that year of the business of $249,152. From there, as is typical in all the tax returns, there is kind of the paper expenses for accounting, which is depreciation, the commission and fees, the insurance and the like, and the other, which again aren't real deductions. Those are just for tax purposes only. Moral of the story is that Mr. Lauterbach is in a far superior financial position. Fact of the matter is that, yes, my client did work in some kind of a daycare years ago, and that's basically a minimum wage part-time job. And that's kind of the crux of the argument that we have. Certainly a need for my client to have some support, certainly an ability for Mr. Lauterbach to pay. And as it pertains to that child support motion, again, it wouldn't make a lot of sense to file said motion, because this would probably be a $50 to $100 per month order given my client's income history and work history. So again, I think the request is very appropriate. We do think it's very reasonable, and we are asking the court to grant that.
Your Honor, if I may just real quick.
Sure.
I do want to point out that my client is just on average, at least since I've calculated back to November, which is when I got involved, he's been sending her an average of $1,000 a month. November, it was the 4th, December, it was the 6th, January, it was the 4th, February, it was the 9th, March, it was the 17th. So yeah, there's a little bit of difference in the dates, but on the whole, that's been a monthly payment to mother. And, you know, even if she were able to find a minimum wage full-time employment, that would make a tremendous difference to her living situation. And so I don't know, I haven't been involved in the case from the inception, but I'm just not sure why, since this thing was filed, that she hasn't been able to find work. So I just asked the court to keep that in mind.
All right, thank you. One thing I just wanted to clarify, it sounded like from the pleadings that the IRS debt from 2021 has been satisfied.
Yes, he has paid that debt, Your Honor.
Okay, all right, thanks.
And the mortgage is current.
Right, yeah, I saw it looked like the arrearages were wiped out, so that's good. Okay, all right, so so taking a look at this, you know, we started at the beginning. The parties were married for roughly 15 years before the separation, and they have one child, and that child is living with dad. Dad inherited a home out in Trout Lake, which I guess is several hours away. I don't know where Trout Lake is.
It is just beyond White Salmon, north, I guess I'd call it north of White Salmon. So it's about an hour and a half east, and then you go north.
Thanks. All right, so there they are. There's Mr. Lauterbach in Trout Lake. And so he inherited that property, and with his business, it sounds like, you know, 2020, it had pretty good growth from 2020 to 2021. Looks like in 2020, that's when he moved there, he started his business, and the gross receipts have more than doubled. Of course, when you double receipts, there's an increase with costs. Like any business, there's depreciation and the like. Those are paper losses, if you will, done for accounting purposes, which, you know, there's good rationale and policy behind that, because that allows for saving of money, so you can replace those depreciated assets as they wear out, as trucks and other equipment are known to do. So when you look at that, there's we know that the mother has been primarily a homemaker, and she has also had jobs in the childcare field. And if you're not an owner or a higher ranking member of a childcare facility, the likely wage is going to be on the lower end of the scale, more towards the minimum wage scale. So even if she were to get a job, which I think she does need to get a job at this point, or get some training, or start moving in a direction where she's can more fully support herself, I think there is a need that she's exhibited through the pleadings, and that there is an ability of Mr. Lauterbach to pay. So when you kind of take a look at things, this is kind of my thinking, is that there's the house, which is an important asset for both parties. At this point, I think it's premature to require anybody to move or to sell the property. This is a very fairly early stages of a divorce proceeding, and it would be premature without to move forward on a sale. So at this point, the mortgage will continue to be paid by Mr. Lauterbach. That serves both parties. That allows a roof over the head of Ms. Lauterbach, and that allows preservation of an important asset of the community. And that's about $1,600. So he'll continue to do that. And then making an assumption that mother gets a job full-time, you know, minimum wage, that's going to bring in roughly a net of between $1,500 to $1,700 a month, roughly. And then you combine that with the benefit of the mortgage payment, which is about $1,600. Let's see, make sure. I think a maintenance payment of $2,300 per month on top of that is, so the mortgage payment plus the maintenance of $2,300 per month seems appropriate. That allows her some ability to live in a style or a form that was similar to prior to the divorce, and recognizing that the father's bookkeeping, it sounds like he seems to be above board, but there's always that temptation for contractors and recipients of those contractors' works to not put it on the books, because both are benefited by not putting it on the books. And then there's some evidence that there's some under the table work that's being done. I don't think a lot's being done, but that there's at least a measure that's being done. As far as attorney fees, I think attorney fees are appropriate. It sounds like there has been some financial support that Mr. Lauterbach has been providing on a monthly basis since November, an amount of about $1,000. And then it looks like there may have been a snafu with the fees and the trust fund and the like. And so some funds have been forwarded to Mr. Zandy's office. So I'll award an additional $2,300 of attorney fees.
You want to just make the effective start date of the order. What's your thought on that, Your Honor?
I always, as a general rule, I like it to be prospective. So April is coming around the corner. So April 1 should be the start date.
And do you want to set a date for the fees to be paid within 60 or 90 days or anything?
The attorney fees. It's not like
Yes.
Mr. Foley indicated that he has some monies within the trust account that could be provided. Is that
Well, actually, no, that's
you don't.
that's what we provided last week.
Oh, okay, so you've divested yourself of that.
Yes.
So I would think a 60-day period to have those fees paid.
Well, Your Honor, if I could we go to 90? I just think with.
I'm fine with 90. That's all right.
90's good.
Okay. All right. Thank you.
Yeah, there's a lot of financial pressures coming down on Mr. Lauterbach with this order.
And then that won't be listed as a judgment that's drawing interest.
The attorney fees, I don't believe so, no.
Okay.
My suggestion is I'll just put at 0% interest and then anything owed after 90 days,
Accrued.
9% or 12% or what, a reasonable amount.
Okay. And then, Your Honor, can we put this on for review as far as mother looking for employment? One of the concerns I have is that, she's just going to continue essentially kind of doing what she's been doing. And we'd like to see some effort made, whether it be, providing us with contacts for the month, that sort of thing.
Mr. Zandy.
Okay, I don't have any objection with that necessarily. We'll provide Mr. Foley reports of that. I'm agreeable to doing that, but setting a review, I'm kind of apprehensive to do because money is tight for my client. We will certainly notify him of her efforts. I'll put in the order that she's to make her best efforts. I'm fine with that moving forward, but I don't think setting a review is necessarily appropriate or cost effective.
Yeah, Mr. Foley.
That's fine. I guess maybe as long as we're receiving, indications, who she's talking with, who she's interviewing with, that sort of thing. I don't want to go 2 months or 3 months and then have her come back and say, well, I've been busy. I've been looking for work, but, we have no evidence of that, because I think, as the court pointed out, adding an extra $1,500 to $1,700 a month to that budget, would make a significant difference, not only for her budget, but for my client as well.
Yeah, I think that the suggestion by Mr. Foley is well taken, that there should be information from mother sent to father via the attorneys about resumes sent and interviews set up and had or completed. I think that provides good incentive for her to continue to look and to not be able to contribute more to her bottom line.
And if I may, Your Honor, as the mortgage obviously needs to be paid, I believe that's the first of the month type of payment.
Mm-hmm.
As to the additional $2,300 that the court has ordered, if we could maybe break that up in some fashion between that first of the month and the middle of the month. I mean,
I'm
otherwise,
fine with that.
Okay.
Half by the 5th, half by the 20th.
Well, I'm just thinking with the mortgage, I mean, what we're talking here now is just under $3,000 a month, or no, I'm sorry, $3,900 a month. So what I would propose is that we do, roughly $2,000 the first, and then the remaining $1,900 on the 15th.
So you're suggesting again was how much the first payment and the second was?
Well, I'm looking at, well, I take that back, Your Honor. The mortgage, I had it down here at 16.
Had it down at 1681, but
1680. Then you add the 2,300 to that, so you get up to 3,980. And so I guess what I was thinking to make it a little bit easier would be make the mortgage payment and pay, what would that be? So 17, so 300, an extra $320 on the 1st or the 5th. And then the remaining balance would be due on the 15th. That cuts it in half in terms of his total financial obligation.
Okay.
Does that make sense?
Yeah, what you're saying is just total outlay per on each of those 2 dates, including the mortgage plus the maintenance.
Would be divided right down the middle.
Mr. Zandy?
Yeah, I'm fine with that.
Okay.
We
So-
make the numbers work. We'll make the numbers work.
Yeah, I'm fine with a lighter amount on the maintenance at the beginning of the month with a heftier or more full, a heftier amount at the later on the 20th. That sounds fine.
Yeah, heftier, right? It's
not insubstantial for sure.
No, I know. I know.
Yeah.
Okay, well,
do the parties want to set a date for presentation?
I think we can agree on an order. Chad, do you have any?
Let's set it for 2 weeks out, and then I anticipate we'll probably get an agreed order to you before then, Your Honor.
That sounds fine. It's good to have that backstop. So we'll set it for April 11th at 9 a.m. for a presentation.
Very well. Thank you.
Great. Thank you, Your Honor.
Thank you.
Thank you, Mr. Zandy.